cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Yeah, it's this time every week we could resort to those awful lawyer jokes that float around, but we don't. Because one's sitting here and he's looking straight at me. David Whiting is a Melbourne solicitor here to take your calls.
I don't mind if you do lawyer jokes.
I haven't got one. I wish I had a really good one. David Whiting is taking your calls, 1300 222 774. Are you ready, my old friend?
I am indeed, sir.
Erica is in East Brunswick. Go ahead, Erica. Erica, I'm sorry, can you start again? That was my fault. Please, go right ahead.
Hi, can you hear me now?
I've got you. No, that was me.
Yes. Perfect. I'm ringing because I was relatively recently made aware of a fine that I received in 2015 but had since had no idea about. And it was with regards to a toll link fine. And when I inquired more about the fine, it was I found out it was for a number plate that I've never heard of, none of my family, no car I've ever owned or anything. I've appealed, and the appeal was rejected, basically saying that there was insufficient information. And I essentially have no other way to appeal because you can only appeal once.
Yes.
So I'm wondering what my next steps are, because I'm wondering how they can possibly give me a fine that I don't believe is even for me.
Erica, I'll take that one on notice. I understand the process. You say it wasn't me. Did you just assert it wasn't you? Did you provide any evidence that it wasn't you?
Well, how do I provide evidence that it's not me?
Well, it's an owner-onus offence rather than a driver offence. So you would ask Vic Roads for a certificate that said the vehicle with that registration plate was never registered in your name. And what you might also do is go to Vic Roads now and get the same evidence, and then go back to Fines Victoria and say, horrible mistake. There's a concept called the slip rule. So if somebody has, for example, rekeyed miskeyed a number, it might be possible to go back to the Magistrates Court and say it's an administrative error since 2015. So, and also you might look at the court file from 2015 to find out if there was an error made then.
Can I ask, why is there only one opportunity to appeal it as well?
Because the appealing takes, it's essentially a hearing de novo for this kind of application. Okay. I'm hearing it again. And if you allowed people to have multiple review rights, the issue would never resolve.
Erica, thanks for calling in. And just while you're talking about taking things on notice, I'm sorry I didn't ask you, do you have any homework from last week?
No, homework free.
All right. And Ross is in Kensington. Hello, Ross.
Good morning. I was recently issued a parking fine for parking over the driveway of a business. However, what was a little bit unique was that was inside the green parking sign, and the business driveway had two giant concrete blocks there that are not movable, and it hasn't been a functioning driveway for that business for some time. So what are your thoughts on whether that is something I could appeal?
Yeah, I would be reviewing it on the basis that it wasn't a crossing. It wasn't a crossing point because of the bollards. And I would be going back to the parking department at the council, and I would be asking them for copies of the photographs which would show that there was no possibility of using it for that purpose. Having said that, there might have been some signs which would indicate something different. So get a letter from the people who occupy the property, get them to write a letter to the council to say how long the bollards have been in place. They probably even obtained a council permit to put the bollards up, so it couldn't be used as a driveway.
Ross, thanks very much for calling in. Jenny's in Ormond. Hello, Jenny.
Oh, hello. Thanks, Justin. Thanks, David. We've got a development happening next door, and they want to raise an electrical wire which just cuts slightly across the very edge of their driveway. They say it's got to be raised 200 millimetres.
Millimetres. You had me worried. 200 metres is...
Yeah, sorry.
I would have thought a bit over the top. Yep.
And there's a potential... So they've got to... There's 6 bolts that have got to be moved on our, taken out on our old clinker brick property.
Yes.
Those bolts go right through. So once they're taken out, water and everything will go inside.
I think, Jenny, that the electricity line will belong to the supplier, not to you. Or is it your wire?
Well, the electricity supply, no, it's their wire. They have to shift it from the pole end, but they've said, no, it's nothing to do with us. It's between us as the owner and the developer. The issue is the compromise, I suppose, or the potential damage to our property.
My worry, Jenny, is that you may not be allowed to simply put it back. There might be additional work required as a result of changes in electrical standards over the last few years. The arrangement by which it is affixed to your property might change. Right, so that would be my worry, not so much about raising the wire, but are you allowed to put it back the way it's connected now? I've got a friend who's a builder, and he was dealing with a property in the northern suburbs, and one of the issues that he had to deal with was, yes, the house connection could be changed, but it couldn't look like the one that was there now.
Jenny, thanks for calling in. Alan's in East Melbourne. Morning, Alan.
Good morning, gentlemen. I wonder if you could help me, please. Parked car in Yarraville, 18th of August. Owner of the car in the house, disabled woman who needs the vehicle for medical attention. She's come out and found her car damaged. A good detective work by neighbours in the street traced it to a hire truck company. Yes. And the leasee was a fellow who was delivering artificial turf to a property. None of that is contested. However, her attempts to get the damage rectified, the obligation on the hirer to provide an incident report, to produce a driver's licence and to pay the excess. He has declined to do that, and consequently the truck hire company's insurance company won't respond.
Yes.
Any thoughts?
The way you've described it to me, Alan, the liability rests with the driver. Right? Now, it depends on who the hirer was. If the hirer was the company that was delivering the turf and the driver was the employee, then I say you've got a claim against the turf company. But if I was a subcontractor and picking up turf at the request of this company and delivering it to a property near your friend, it's me as the driver that's liable, no one else.
The hire company says that they engaged this fellow as a driver. Clearly, he doesn't have a driver's licence, and so that's why they can't furnish the necessary to the hire company. Police are relatively disinterested.
Stop. Can we go back? If the hiring... Was the hiring done by the turf company or by the person who did the driving?
Turf company.
Then my view is that they're vicariously liable for the person who was doing the driving. Because it's an employment arrangement.
That's what we've indicated to them also. The turf company and the driver are both refusing to pay. Police are relatively disinterested in a $4,000 property claim.
Well, what's the crime? The crime is failing to report an accident, not a $4,000 property claim, but failing to report an accident. That's the offence, if you like. Do you have details of the driver?
Details of the driver, his non-driver's licence, his address, all this has been acknowledged.
Then the answer is it's a magistrate's court matter.
And how do I take that to the court?
You issue a complaint and summons. Have a look at the Magistrates Court civil procedure rules. There's a process for doing it. And I think have a look at the Nunawading Legal Service. They used to have, they may still have, a kit for people who want to do their own traffic claims.
Alan, if I could jump in there too, you said you went to the police?
Yes, it's been reported.
Okay. And so I'm not trying to put words in your mouth, clear me up if I'm wrong, did you say they weren't interested?
No, that's my take on it. We're in a situation where the police in the northern and western suburbs are on a go-slow at the moment, as reported on ABC News yesterday. And as I say, they've got it's a relatively low-level case as far as they're concerned. They've got bigger fish to fry out in those areas. But the hope had been that should police appear make inquiries as to what had happened, that this might prompt the owner of the Turfgrass company to pay for the repairs and get the matter out of his hair.
But it's really your issue to run at the magistrates' court. Whether the police prosecute or don't prosecute is entirely up to them.
Alan, thanks for calling in. Honey's in Baronia. Hello, Honey.
Hello.
Hello.
Honey, go right ahead.
Oh, hi. Friend of mine recently went to Bateman's Bay and bought a motorbike, a BMW motorbike, with a roadworthy certificate. Now, she rode it back from there, and because she hadn't ridden for a few years, she thought she was a bit, out of touch with her riding. But anyway, when she got it back to Victoria, she's taken it to re-register down here and, of course, has to get a roadworthy certificate here, taken it in somewhere to get it done, and it has not passed at all. And there are multiple things wrong with it, costing her upwards of $3,000 already.
I would be going back to the people who provided the roadworthiness certificate in New South Wales, and whoever the New South Wales equivalent of Vic Roads is, get a report from the people who've done it here, and I'd be putting the onus on the people who said it was roadworthy in Bateman's Bay.
Thanks very much, Honey. Thank you for calling in. Frank's in Clayton. Hello, Frank.
David.
Yes.
I went to a solicitor for a quote of the fee, the charge to do the work. Now, he went. He got appraisal for the properties, for Victorian property. Then he sent a letter to a Queensland solicitor, and we didn't sign any paperwork at all. Now, are they entitled to charges for that?
You have to make up your... I had a similar issue with a client 3 weeks ago, where in order for them to tell them what they needed to do and what it would cost them, there was a fair bit of work from my point of view, rather than, oh, look, I'll go and look, and looking will cost you X. And we had a disagreement. You need to come along and say, did you engage the lawyer to do anything other than provide you with a figure? And I would have thought if there was an appraisal done and correspondence with a lawyer in Queensland, I think they've done something. They can't charge you for preparing the quote, but there may be a basis for charging you for the work that needed to be done before the quote could be provided.
Frank, thank you very much for calling in. It's 19 past 10. Back with more. David Whiting in a moment.
This is ABC Radio Melbourne with Justin Smith.
And Mark is in Preston to talk with David Whiting. Go ahead, Mark.
Good morning, Justin and David. Hope you're all well.
We are. Thank you.
I hope this is quick. I'm getting close to paying off my mortgage. And when I contacted the lender to see what I have to do at the end of it, they said during their processing, they will destroy the original certificate of title and send me a number.
Yes.
I've been waiting for years for that bit of paper in my hot little hands.
Can I ask you, Mark, is your lender one of the major banks?
No.
Okay. What the state government has asked us all to do is to move to electronic titles. So the ownership of your property is recorded on a government database rather than on a piece of paper. And all of the major banks about 6 or 7 years ago, perhaps a little longer, converted all of their titles to electronic. And in so doing, to comply with the requirements of the Registrar of Titles, destroyed all the physical documents, right? So they moved from paper to electronic in a one fell swoop without asking their clients, was that in order? Now, if the discharge of your mortgage is required to be undertaken electronically, not manually. So that requires your lender to nominate the title, to an electronic settlement, and in so doing, tell the settlement company that they have destroyed the original. So that's why they're doing it. Now, simply because that's the only way they can discharge the mortgage. Don't discharge the mortgage, it'll sit there for a long time.
Is there any way I can get that bit of paper, even if it's stamped invalid? Like, I feel cheated.
It's only,
I've waited so many
yes,
years.
I understand. Only by negotiation with your mortgage provider. And you simply say, I'm very happy. Sorry, I recognise you need to convert it to an electronic title, but there is a way of rendering it invalid without shredding it. And that's what you want them to do.
Mark, thanks for calling in. John's in Brunswick. Hello, John.
Hi. Yes. I had to change GPs. What was a bulk billing GP became a women's health paying surgery. So I found a new bulk billing GP.
Yes.
I signed something that says they may seek out my previous medical records.
Yep.
And I received an email from the first surgery requesting $40 for transferring my records, which seems a lot for Control-C, Control-V.
I think it's slightly more than Control-C, Control-V, but I'll have a look at the Health Records Act and tell you next week whether they can or can't charge a fee. My view is they can, and you know, the records will be slightly more than dumping documents from one Word file into another, but next week I'll tell you, John.
Keyboard-based. Well, certainly they have been in all the time I've been there.
Okay. John, thank you very much. We appreciate it. Jerry's in Blackburn. Hello, Jerry.
Hello, Jerry.
Jerry, we got you?
Hello. Good morning. Thank you, David. Thank you for taking my call. I have a home and a brick home, and during the recent storm and strong wind, the gable part end of the front brick wall collapsed, and my insurance company sent an engineer came in and investigate, and I got an email from them and said, due to the house is 50-year-old, the mortar of the brick wall and have a moisture degradation over the years, and it's not their liability.
Jerry.
Okay, so
Jerry,
I just want to repeat that. So Jerry's saying the front wall was collapsed because of a strong wind, and the insurers won't.
The
front
insurer
up for
has
it.
declined.
Yeah.
The insurer's declined because 50-year-old house, the mortar's failed. There's moisture, so there's a whole series of issues. So it was going to fall sooner or later. Jerry, it's really a question of what your insurance policy says. You've signed a contract with your insurance company, and the essence of it is contained in a product disclosure statement. You need to read the product disclosure statement and work out whether you're covered. If you're not happy with the decision being made, you can seek a review of the decision.
Jerry, thank you very much for calling in. Charlie's in Elwood. Hello, Charlie.
Hey, good morning. In May this year, we had a fire service pipe burst to my apartment block. It's a group of 10 apartments. And the pipe burst sort of like in the middle of the road because it runs from one side of the road under the road. So it's not really maintainable, but I believe it is property of our apartment block.
Yes, what happens is while the meter's inside your fence line, you're responsible for everything between the main and the meter.
Yep. So we have since gotten that replaced and fixed at a cost of $30,000.
Yep.
Which drained our maintenance fund and everything. So anyway, I thought, all right, suck it up. That's the last we'll hear of it. We've since just last week got a claim from someone saying that their car was damaged. It's the first anyone's ever heard of a car being in the way, and the claim is for $40,000.
Wow.
There's $22,000 car repairs and a $14,000 vehicle hire.
Wow.
It just seems like I understand we own the pipe, the building, but
is it covered by your insurance policy, Charlie? I thought it would have been.
You would think so. I did ask at the time, and I was told that the strata manager told me that the claim had been basically knocked back by our insurance company. So that's something I should dig deeper into. But
Absolutely. But the other thing you should do is get some more information in relation to the damage, because I would be, if how long ago did your the pipe go, Charlie?
it was in May 8th this year, and they're now sending a letter.
So I can't believe that they've waited this long to make the claim.
And they sent a very threatening respond in 72 hours, and they haven't sent any details. So we haven't responded yet.
No. I'd want more information about the repairs, when the car was taken in, what it was, water damage, independent evidence of the loss. I'd be looking for that, as well as going back to your insurance company.
Okay. All right. Thank you very much. Appreciate it.
Charlie, thanks very much for calling in. Ross is in Moorabbin. Hello, Ross.
Good morning, gentlemen. My issue is we've got a vexatious neighbour in our apartment block, constantly goes to the police, makes false stat decks about issues, claiming that we're damaged property or whatever, and then it's proven that it isn't the case. Is that something that we as a committee or myself would have to go to the police and say, hey,
no, sorry.
He's actually...
I don't understand. We as a committee, I mean, I thought you were talking about your partner when you said we have a vexatious neighbour. Are you in a block of units and one of the units is irritating everybody else?
Correct.
Yeah, okay, slightly different. Yep.
All right, my apologies.
No, that's okay. I just a misunderstanding from my point of view.
Okay.
So why would you not go and get some kind of, I would have thought the argument will be the police will sooner or later get sick of him.
Well, I mean, we're sick of him making these false stat decks, and I believe that there's a criminal offence or a fine.
It is well, why would you not go to the police and say, this guy's made 20, 30, 40 statements which are not true?
Yep.
But it's then up to the police to take him to court to argue that he's made umpteen false statements.
Ross, thanks very much for calling. So your advice for Ross, go back to the police.
If provide the evidence and then say, look, he's done it this many times, would you consider prosecuting him for making false statements?
Last call, I think. John's in Blairgowrie. Good morning, John.
Yeah, good day, David. I've got a common driveway with a battle axe block at the back. It's not my driveway. And the previous owner put in some for a hedge, and they're growing 20 feet high. And the new owner wants to keep the hedge, but has mentioned that she'd pay if we kept on trimming it, and it'd need to be trimmed every couple of months. The rate this thing grows.
It would also need to be. Well, I'm dealing with a similar issue at the moment, John. The tree, I would have thought that the height of the tree would also cause a problem after a period of time. So if you get an ornamental pear that grows very quickly and very tall and that sways a little, so it would be possible, if you were feeling terribly unkind, to apply to the Magistrates Court for an injunction requiring that the trees be lopped and trimmed by your neighbour. So the expectation at law is that you'll keep the whole of the tree on your property. I know that's not practical, but that's the law.
Can I just jump in there? Who owns the land? Who owns the land in the driveway here? Because so John says, well
John says two things. John says it's a shared driveway, and then he says the other guy owns the driveway. So
no, we both own it. It's common property.
Oh, okay. It's common property, and the trees are on common property, are they?
Yes. And I never agreed to have the hedge there anyway, but it looked...
Then it's a dispute you can take to VCAT between owners in a two-lot plan of subdivision.
John, thank you very much for calling in. It's 29 to 11. Don't take your headphones off yet. I've got a final text question for you here. It's a very important one. David says, anonymous, David, can you tell me how to get out of attending my work team Christmas lunch?
No.
Get a really good lawyer.
No.
You can't help?
Well,
You got nothing?
Just come and leave early, you know. I mean, probably if it's a work team Christmas lunch, you're being paid to be there.
Oh, can you not? So it'd be a sickie, not that you would advocate for such a thing.
No. Well, sorry, I get so stressed at the concept of going to a Christmas party.
Okay, that's the way out. All right,
Well,
okay,
maybe.
fine.
Thanks, that's your advice, Justin.
Ladies and gentlemen, no, don't pin it on me. Ladies and gentlemen, Mr. David Whiting, Melbourne solicitor. He will be back next week.